Hi, everybody. Thank you for joining us today. We're going to talk about New York's new and improved power of attorney. We're 2 days late for me to say this, but happy birthday to the new New York State power of attorney. As of June 13th, 2021, a new law went into effect regarding our power of attorney documents. So happy birthday to the power of attorney. We're right there at a 1-year mark. So what I'm going to do today is start by explaining what is a power of attorney, what has changed, and what you can do about your older documents, if anything. And then, as Liz said, if you have any questions, please put them in the question and answer box on your screen, and I'd be happy to go through those at the end of the program. So the power of attorney, what is it? So in other states outside of New York, there's a medical power of attorney and a financial power of attorney. In New York, we only have a financial power of attorney. Our companion healthcare document is a healthcare proxy. So we have a different name for that. The New York State power of attorney is created under the General Obligations Law of New York State, and it is a document that allows another person or persons, depending on who you name, to step into your shoes and handle certain personal things for you. I call it the business of your life. So exactly what they can do is going to depend on how the document is drafted and what powers you're choosing to give up. But if it is an all-inclusive power of attorney, it often is giving somebody the powers to handle banking transactions, real estate transactions, insurance transactions. We can give the power to open a safe deposit box on your behalf, to open accounts, close accounts, transfer assets into trust. All of these things can be done on your behalf, but only if you do it right, only if the document is drafted properly. And that's what we're going to talk about today. So at the very base, the power of attorney is a document. It's a document that confers power to another. In most cases, this document does not depend on whether or not you are incapacitated. So it is a document that's in effect when you sign it. The person signing the document is what we call the principal, and the person they are naming to act on their behalf is the agent. The principal must sign the document and the agent must sign the document for it to be fully executed and able to be used by that agent. There are, in some cases, a monitor in the document, and we don't put that everywhere, but sometimes someone wants there to be oversight or someone who can request an accounting from the power of attorney, and that would be the position that the monitor would take. There are many powers of attorney, or I shouldn't say many, there are some powers of attorney that are what we call springing. What this means is that there's a specific provision in there that says that somebody only rises to be the agent if the principal is deemed incapacitated by a doctor. There's a lot of problems with doing that, and part of it is that it's often difficult to get a doctor to pass on whether or not someone has the mental capacity to handle their own financial affairs, because the doctor doesn't want to get involved in that situation. And so very often we end up where if there's a springing power of attorney, we have trouble activating it because we can't get the proper documentation from a physician. The other issue is that there are many people who still have mental capacity, but they would like, as they become more infirm, for their agent to be able to act on their behalf, but still do things themselves. And if it requires your incapacity, you can't use the agent as that second hand, as that help. So very often, we just like to tell people, you'll sign the document, your agent can sign it, or your agent could sign later, but that document doesn't have to be presented to a bank or to another institution to be used right off the bat. You can revoke that document, a power of attorney, at any time during your life, and a power of attorney dies with you. So if somebody passes away, the person who was named as agent on their power of attorney immediately loses the power to act on that person's behalf, and it turns over to either the beneficiaries or the estate to handle those assets. So a little history about the power of attorney document that'll help you as you're thinking about what documents you have and where your power of attorney stands in this historical outline. So in 2009, there was a very large change to the power of attorney law, to the general obligations law. And what it did was it said that the power of attorney document only was as good as how it was written. So that means that if a power was not specifically stated in the document, the agent doesn't have the power to do that thing. So if you don't have the power in the document to create a trust, then the agent didn't have that power. Prior to 2009, it was a much shorter document. It was generally a two-sided piece of paper, and it got much more complicated after that. 2009 also added a major statutory gifts rider, which was later titled a statutory gifts rider. That rider said that you had to put in the power of attorney document that you had at the same time signed a gifts rider, and then the rider was attached, which was also signed, which gave all gifting authority. And in New York State law terms, gifting authority included creating a trust, transferring assets into that trust, giving assets to a spouse, giving assets to a child, giving assets to a charity. Any transfer of assets out of your own individual name required that gifts rider and that the power be specifically stated. In 2010, just a year later, there were minor changes to the statute. It changed from a major statutory gifts rider to a statutory gifts rider, and there were some other small items that were changed. That was our power of attorney from 2010 until a year ago. That was the document we were living with. Now, the new law states that as of June 13th, 2021, any power of attorney that is signed by somebody, a New York State power of attorney, must be signed in accordance with this new law. The new law did several things. It got rid of the statutory gifts rider. It didn't get rid of the requirement that those individual gifting powers still be listed in the document, and they are listed now as modifications to the document, but it got rid of the rider as a separate document. It changed what we call substantial compliance versus exact wording. So with the prior statute that we had, if one word of the cautionary paragraph at the beginning of the document was off, the whole document could be found to be invalid. But now we go by substantial compliance, which is if there is a small error or a small deviation from the form, as long as it's clear what the intention was of the principal and what the document is looking to do, that could still be a valid power of attorney document. It also changed the signing requirements. It used to be that the power of attorney was signed by the principal and then notarized. And then the principal also signed the statutory gifts rider, where there was a notarization as well, and then two witnesses, one of which could be the power of the notary. The new law, with only one document, no rider, states that the individual, the principal, will sign in front of a notary and two witnesses. And really, it's a notary and one witness because the notary can be one of the two witnesses. Another really great thing that this new law does is it allows for someone else to sign the document on behalf of a physically incapacitated person. So I'm going to give you an example. Right after this law went into effect last year, we had a client who had to sign a power of attorney. She had her mental faculties completely. We were able to have a conversation about the document. She understood. We discussed who she wanted to name as her agent, why, who might be backup, all of those things. We were able to have a full conversation about them. But because of a disability she has and a physical inability to hold a pen and sign a document, she was not able to sign it. This new law allowed for me to sign on her behalf. Now, I can't just go signing a power of attorney on everybody's behalf, But what the law allows is for a third party, another person not named in the document and not one of the witnesses, to sign if in the same room as the principal and at the principal's direction and instruction. So we went to her. It was myself, a notary, and my other witness. She instructed me to sign the document on her behalf after we reviewed it together. I signed the document, my name, making it clear that I was signing on her behalf, so her name and my name. And then I had my notary notarize it, and then the notary and the witness signed as witnesses. And this is a valid power of attorney now. This is a really great change for the physical, those with physical disabilities or physical inabilities to sign. We used to have to do an X on the document and help the person sign it. And then we had to do an X affidavit, and it was much more complicated. So this is a really great thing for those with a physical disability. Remember, that doesn't take away the fact that this person needs to have the mental capacity to sign the document. It's just if they have a physical inability that we can do so on their behalf. The other thing that I want to point out in the document, which was the same from the old document to the new document from 2009 on, is that the agent must sign the document and have it notarized before they can act. So if I am the principal and I sign a document, I have it notarized and witnessed. Before my agent can go use that document and access bank accounts or whatever it might be that my agent is doing on my behalf, they must sign it, accepting the responsibility in front of a notary, and have the notary affix their seal and put the date and signature. And so it is not a fully completed document, although it is valid prior to the agent signing, the agent can't use it until they sign. And again, some clients use that as a way to say, if something happens to me, this document is here and it's signed, I've executed it, but I don't feel comfortable yet giving another person access to my accounts. Therefore, I'm going to hold off on having my agent sign. And that is up to the principal, and we've discussed that on a case-by-case basis. But I have to stress the fact that while these are forms, right? So when I talk about the law changing, I'm talking about the form changing. It's a form that requires more than just the standard. So there is a power of attorney standard form in the statute that gives certain set powers, and the agent, the principal can initial next to specific powers or initial the catch-all power. But there's also a modification section. This is where we add in gifting powers. This is where we add in the power to create trusts. This is where we add in the power to access safe deposit boxes, apply for government benefits, etc. So the modification section is extremely important, especially when doing elder law planning and planning for long-term, because those are the types of powers that might become necessary as somebody gets older. I also want to point out the term durable power of attorney. People come to me all the time and ask if their power of attorney is durable. All powers of attorney in New York State are durable unless they state that they are not. The form that we currently have is not titled durable power of attorney. It's just called a power of attorney. However, it is still durable unless it says it isn't. Durable means it's in effect now when I sign it, and it remains in effect if I become incapacitated. So that's what durable means. And you're basically always going to find that a power of attorney is durable unless someone specifically chose for it not to be durable. So now I just want to talk a little bit about the gifting. So the statutory gifts rider, as it was called before, or the gifting powers and the modifications as we do now with the new law, are always a really stressful conversation for clients. I always say that the state uses the term gifting because it wants you to pause. It wants you to look at who you're naming and the power that you're giving them and truly understand if that's something you feel comfortable with. And so even if it's transfer of an asset from your name to a revocable trust that's fully for your benefit, that is still gifting. And so there are certain gifting powers that we want the agent to have, because we want the agent to be able to do certain types of planning later in life. But there's certain powers that aren't necessary. And so generally speaking, we'll have a broad power of attorney document. And then if there's a specific power that makes someone uncomfortable, we can discuss the power and talk about the pros and cons and see if it should be removed. This is why this document, I believe, requires an attorney rather than a healthcare proxy, which can be signed with any two witnesses. It doesn't require a notary, and very often people sign it in a hospital setting or something like that. The power of attorney, because we're giving the power over your finances and your assets, we really want to make sure that you have legal advice to understand, do you have the document that is going to serve your needs? And do you understand the power that you are actually giving away? Another big change in this new law is that it put into place a procedure if a third party, and we often think of banks, but it could be title companies on the sale of a property, an insurance company that you're trying to get information from, anywhere where the agent is presenting that document because they want to act or speak on behalf of the principal, that's the third party we're referring to. And what the new law did was it gave to the third party a procedure to follow when they want to deny the use of that document. And if they want to reject the document, they not only have to file the prescribed method of doing so, but they have to be reasonable in doing so. And if at the end of this time that they have to do this, if a proceeding is brought and it's found that they were unreasonable in rejecting the document, they can be given sanctions and have to pay attorney's fees and damages. And so we're looking to put some teeth into the law to hopefully make it so that these documents can be more usable as people become incapacitated, and have the institutions be very clear on what their process is to follow if they want to deny a power of attorney document. So what happens now is if an agent under the new law is if an agent presents a document to the, let's say bank, because it's the easiest one to think of, to the bank because they want to be put onto a bank account as the power of attorney so they can pay bills out of that bank account, the bank must in writing state that they are rejecting the document. They have a certain amount of time that they have to do this within. And if they don't do it within that time, they can then be held liable. Also, if they reject, then you could come back with an attorney opinion letter and say, no, this is why it should be accepted. And then they have 7 days, it's 10 on the front, 7 on the back end, 7 days to come back and say, no, we're still rejecting it, and this is why. And then if the agent believes that this is unreasonable, then they can bring a proceeding. If you have a current power of attorney document, it might still be okay. I am not recommending that everybody with a power of attorney from before June 13th of 2021 have it re-executed. That is not necessary. However, if you have a document from before 2010, so back to that 2009 law or worse, back to when it was a 2-page document, I know we love our short and sweet 2-page documents, but please redo the document if you have the mental capacity to do so. Because what we're finding is that when those documents come up now for an agent to use, and the principal no longer has the mental capacity to sign a new document, we end up in a rough spot where the agent doesn't always have the powers that they need to do what's in the best interest of the principal. And so in the matter of efficiency, we want to have the best document possible. So you do not need to redo your old document. However, you should probably have it reviewed and speak with your attorney to see if it makes sense for you to have it redone, and if the document that you have is going to suit your needs. A change in the law like this is always a great reason to pull your old papers out, take a look at them, remember who you named. Does that person still make sense? You know, sometimes I look at a document with someone and they say, wow, I forgot that that's who I named as agent, and they live overseas now, or they live in, New Jersey or wherever they might have moved to, and that's not the right person any longer. And so a change in the law is a great reminder to go back to your estate planning documents, to take a look at them, and to make sure that if something were to happen now, either in capacity or with some other documents, your death, that those documents still suit your needs and follow your wishes. I will add in that along with the power of attorney, you should always make sure that you have a healthcare proxy in place, naming who will make your medical decisions if you are deemed incapacitated by a doctor and can't make them for yourself, along with other specific healthcare documents specific to your treatment options, and then also a will and or trust, depending on your circumstance. I'm going to stop now and see if there are any questions. I see we have two questions. One is asking why not to use LegalZoom or a Staples template. That is a great question. I'm glad you asked it. So the reason that we don't like to use the templates is, one, as I said before, getting legal advice when signing this document is incredibly important. And when you download those documents, you don't have the benefit of an attorney telling you the pros and cons of all of the options. You also, on those templates, would not have any modifications put into the document. And as I said before, while you do have specific standard powers that are in the document, anything that goes beyond that standard A through O on the that first section of the document is not going to be in a LegalZoom or a Staples template. So that's very important. Also, I find that many times when people use those templates, they're not New York specific. They don't comply to the New York law, or they comply to an older New York law. So it might be that you're on the 2009 document in 2022, or you're on the 2021 pre-June document in 2022, in which case you're not actually creating a valid power of attorney. To me, it is one of the most difficult things to explain to somebody, especially to the family member of someone who's now become incapacitated, why the document that they thought they had, they thought they took care of things, they thought they were on top of it, why that document is not valid and won't help them. And it's as good as having nothing. So I really urge you not to use those stock documents. The next question is whether or not you need a separate power of attorney if you have homes in two separate states. So you should have a power of attorney in the state in which it is your primary residence. 100% that's necessary. There are some individuals, like for example, if I have clients who go back and forth between New York and Florida, who find that it's in their best interest to have a power of attorney document in every state where they reside. It's not necessary. And New York State has, if done properly, has such a robust power of attorney that I find that it works well in other places. The bigger power becomes that if people have a simple document from a state that doesn't have such a specific statute. I actually recently saw a client's document from one of the New England states that does not have as robust of a statute as New York does. It actually, while valid in New York and while it can be used in New York to do the things that are listed in the document, it would not help with many things that we need to do because that document in that state doesn't require all those specific powers be listed out. So I think it's very hard if you have an out of New York document that you're trying to bring into New York. It's probably easier the other way around. Okay, so let's see, we've got some more. Yep, so there's a question here about how to revoke a power of attorney. So the revocation part of the statute is actually the same now as it always was before. In order to validly revoke a power of attorney, you must sign a document stating that you wish to revoke it, and the document, the date of the document that you're wishing to revoke. You must sign that in front of a notary, have the notary acknowledge it and sign it and affix their seal. And then that document must be sent, I believe it's certified mail, although I always go back to the statute to check myself. but it must be sent to the agents named in that document to put them on notice that they are no longer to act under that document, and to any institution that has a copy of that document who's been relying on it to act. And the idea behind that being, how can someone know that they can't act as power of attorney anymore? And how can an institution know not to honor it if they don't receive that written revocation document? So that is how you revoke a power of attorney while you are still alive. Just reading this next question, it's talking about the gray areas of mental capacity and how much capacity is needed to sign a document. So a document is sometimes the question is also about whether or not to have a doctor's letter following up the document. So it depends. It is not my standard practice to have a doctor's letter with a power of attorney. I start to get nervous because if I believe somebody does not have the mental capacity to sign a document, there might be a doctor's letter that is provided to me, but it's not something that I would seek out. My decision as to whether or not somebody has the capacity to sign a document is whether or not that person understands what they are signing. So the decisional capacity is, have they reviewed the document? Do they understand what the document says and what power they're conferring? And do they consent to that? And so that is how we determine whether or not somebody has the ability to sign that document. And that's going to be different in every case, depending on, and this person comments that capacity is not necessarily all in or all out. And certainly if somebody, not everybody has the same level of capacity at all times. And sometimes people are much more lucid certain times of day. And so it's just making sure they understand fully what they're signing. Well, thank you everyone so much for joining us. It was a pleasure. I hope you enjoy the day, and happy birthday to the power of attorney.